We're going to take a little time, basically 1 minute each for each panelist to comment, react to anything that they've heard. They're not required to say anything, and I'm going to yield my time to Valerie Nannery because she's a little outnumbered down at that table there, so she's got a little extra time in responding to this. Joe, do you have anything you want to add?
I just wanted to add one thought to your remarks earlier. When you talk about the reverse payments, I think to economists, it's interesting to stop before you go too far. When you think about a patent on a drug, that doesn't necessarily confer monopoly power. That's one of the reasons you might want to do a rule of reason analysis. There may be many therapeutic equivalents that could be chosen by a physician, and so just because you have a patent doesn't necessarily confer onto you an economic monopoly that economists would recognize. But
good point, and I meant to say it, so thank you. Owen.
Thank you. Just a quick one. The PDR, which is the physician desk references, only contain information regarding brand names. So therefore, if you're using generic names, good luck to you with regard to the references unless you buy a separate book or use the Google. Of the approximately 11,487 drugs, about 67% of the prescriptions prescribed are generic, and there's counterparts to all of them. Just a quick one with regard to the new black box warning with regard to Reglan. Let me read a warning. Tardive dyskinesia, a syndrome consisting of potentially irreversible involuntary dyskinetic movement, may develop in patients treated with metoclopramide, which is Reglan. And there's both the risk of developing the syndrome and the likelihood that it will become irreversible are believed to increase with duration of treatment and total cumulative dose. You need to ask yourself what that warning really says. If you were taking a case and the case says this case is only good for those cases that are incept after 2009, and it's in a footnote, and for some reason the lawyer doesn't refer to it, and you get it in a brief, you need to ask yourself whether you might kill him. Oh, by the way, the warning that I read to you was not the black box warning that is presently in place. That was a previous warning. English is my second language. I certainly understand what it says. Thank you.
Thank you, Owen Lee. Valerie?
Oh, there's so many things to respond to. I'll take that one first. Tardive dyskinesia was warned against on the Reglan warning. However, it said it was a relatively rare side effect that occurred in 1 in 500 patients. It was, and it said that you shouldn't, that prescription for more than 12 weeks had not been studied. And then it was changed just a couple of years ago after Ms. Conti had already developed this condition to say you shouldn't prescribe this drug for more than 12 weeks, but it didn't prohibit doctors from doing so. It didn't put it in a black box. And so the warnings have been made much stronger in 2009 than they were originally. But I wanted mostly to respond to this concept that the Conti decision holds the name brand manufacturer responsible for the wrongs of the generic manufacturer, and that is not what it does. Under Wyeth's conception of it, they should be able to escape liability for their own wrongdoing and their own misleading statements simply because your doctor does not check that box at the bottom saying dispense as written. It is just based on the fortuitousness of you actually receiving the name brand drug instead of the generic drug and paying more for the generic drug. There is no requirement for a fraud case or a negligent misrepresentation claim that the person making the misrepresentation actually benefit from that misrepresentation. They'd simply have to make this misrepresentation, know that it's a misrepresentation or reasonably should know, and know that you're going to reasonably rely on it in making your decisions, and then somebody's harmed. There's no requirement that the name brand manufacturer receive any money. And Conti isn't the only case to have held this. You heard earlier on the first panel about the off-label use of Neurontin, and there is a case in the Philadelphia County Court of Common Pleas where Pfizer, a name brand manufacturer, in a class action lawsuit filed by users of Neurontin who did not have the condition for which it was approved, but yet had been prescribed the drug or its generic counterparts, sued to recover the monies spent on that drug. Pfizer said, well, you cannot hold us liable for the money spent on the generic drugs, that those weren't our drugs. And the duty analysis done by the Philadelphia court was the same. It was for pecuniary loss, which is different than a claim for personal injury as it was in Conti. However, the duty analysis was essentially the same. And based on the contours of pharmaceutical regulation, it was foreseeable that the name brand manufacturers' actions spreading information about a drug would lead to not only more prescriptions of the name brand drug, but also to prescriptions of the generic drug. And I wanted to, so I have too many other things to say, but I wanted to end that thought and pointing out that name brand manufacturers, knowing that once their protection expires, often create generic counterparts of their own so that they can benefit from the promotion of the name brand drug that they have done. In fact, Wyeth had a generic version of metoclopramide on the market for a long time. They didn't make, Ms. Conti didn't receive that particular generic drug, but she could have if it had been at her at her pharmacy when she turned in her prescription. So it is not necessarily true that name brand manufacturers do not reap any rewards when a generic is used in place of the name brand prescription.
Bert?
I don't want to be argumentative. I'll say that everything Valerie said was true but inconsequential. Because it all goes back to the man from Mars test. Yes, if you continue to sell a so-called branded generic and somebody takes it and you have inflicted that harm because the drug is unreasonably dangerous, that is, your warnings are not sufficient, then traditional product liability theory says you're responsible. But as Victor said, creating a duty requires a relationship. And if you really follow Valerie's logic, take this scenario. A doctor sees another doctor in the corridor of a hospital and they chat, and the doctor said, I have a remarkable result in using drug X. Really think it helps my patients. You ought to try it. Second doctor tries it, doesn't recognize all the risks of the drug, somebody's injured. Now the question, well, whose problem is it? Answer, well, the first doctor could foresee that acting in reliance on his endorsement, the second doctor would prescribe the drug. And certainly with magic of hindsight, you'd see that. You should have known that when you made that remark, it was going to influence the prescribing behavior of your colleagues. And my gosh, look what happened, and it's all your fault. There's got to be a line in which foreseeability is insufficient or irrelevant. I think that one thing that Victor pointed out, when you talk about externalization, who ought to bear it? There's a loss out there, and who ought to bear it? There's a function of tort law which says a wrongdoer ought to bear it. Somebody who has a relationship with you or even remotely by benefiting from a product sale to you may be the person to bear the loss. There are other instances where it's a legislative decision. If you want to look at kind of the paradigm of it, think about the Superfund. You have sites all over the country that have been the subject of industrial waste, and now they're dangerous and they create a problem for the community. You could start to invent nuisance theories and other theories saying, well, the people who created these sites, they really ought to pay for the cleanup. That's not how it was done. Congress made a decision, yes, we'll clean them up, and imposed a Superfund tax as a way of saying, as a public policy, as the legislative decision, the loss shouldn't be borne by the people who live next to it. It ought to be spread, and we can do that legislatively. There are things that we ought to decide by the democratic process. There are things that courts can decide, but when they move across the line and deny a relationship, they enter the legislative realm, and that's a serious mistake.
Victor, do you have anything else to add?
This, in the material, I just want to explain, because some of our stuff is in these materials, very briefly. We have an article that was just published in the Harvard Journal of Law and Public Policy about direct-to-consumer advertising. You might find it of interest. There is an article about, will be published in South Carolina Law Review, where we opine about the Supreme Court, actually Justice Souter's opinion in Exxon Valdez, and it may be helpful to common law judges in trying to set limits on punitive damages, not as a matter of constitutional law, but your own law. And finally, I would mention that I wasn't here for Wyeth versus Levine, and there's a lot of debate over it, whether the decision is right or wrong. But as a common law judge, you still have the opportunity, without any mandate from the Supreme Court, to decide how much credit should be given to the fact that a drug was approved by the FDA. And I'd suggest you take a look at the Products Liability Restatement I think it's Section 4, which is very good because it says in different circumstances, regulatory compliance should have different results. Sometimes the agency has really looked at something very, very carefully. They've had open hearings, they've heard from all sides, and they've done a darn good job. And in that situation, maybe deference should be given. But that's up to you. The Supreme Court has left it up to you to decide how much power should be given to a compliance. And the court did not hold that you cannot do it. All it said is the government is not putting a gun to your head and making you do it. And that's my final point.
Great. Thank you very much. Well, we have a few moments for questions, and please wait until the mic gets down to you. We'll start off right here in the middle. Come on down, run on over, dive.
If the PDR does not disclose generics, how can manufacturers and physicians have a duty of foreseeability?
That's essentially the evolution of medicine, as I indicated. If you belong to an HMO, it's run by a formulary committee, and the formulary committee only approves those drugs which allow those physicians to prescribe for. For example, many of the so-called health maintenance organizations have rules that detail men are not permitted to discuss their drugs with your doctors at all. They're not allowed to get on campus at all. So therefore, the formulary itself sets forth the drugs and sets forth the information. The generics are good, but you must understand that the HMO, the so-called HMO doctors have a financial interest also. Let me give you an example. One of the drugs that I posted up on the screen earlier was an ACE inhibitor. ACE inhibitor is for essentially angiotensin converting enzyme inhibitor for hypertension. But it has the side effect of cough. In fact, as much as 25% of the people have a cough syndrome from it. And also it's not necessarily the best drug. In fact, the better drug might be a drug called Cozar, which is an ARB, which is a blocker instead. But everybody has to start with an ACE inhibitor because now with the so-called electronic prescribing, in order for the doctor to prescribe the second drug, he's got to say he's prescribed the first drug first. Otherwise, he can't override it. If he does override it through what they call an exception, later on when it comes times to evaluation, if someone's in a senior capacity, they ask him why didn't he try the so-called ACE inhibitor first. So to the extent that there's generic information, as you know, the internet has a lot of it, and the formulary committee generally puts out a certain amount. And two, in medical schools, you do learn primarily the drugs, and now since almost two-thirds of the drugs are generic, that's basically the way you learn it. But you must understand also that because it's a generic, the generic drugs companies don't necessarily, promote further research in these areas, so whatever research there is in it, it becomes a standstill.
But how does the practicing physician keep up with the generics which keep popping up as drugs move along?
Most doctors are old. And so these drugs were around in brand name when they first started. You just understand, you don't get out of medical school normally until you're in your 30s. Now, Phenergan is actually was a brand name by Wyeth too. It's just Wyeth is getting killed here, but it's now available in generic form. So you basically learn it through your practice, because the hospital he practices at has a formulary that says you only can use generics, so he learns it there. He goes outside, and the patient is a Medi-Cal patient, and the so-called the state-provided medical assistance works on a formulary. And then you go out further, and then you have the Walmarts out there that says, we'll give you a special price on generic drugs. So the patient asks for generic drugs.
Well, just to respond, I mean, the PDR that is a voluntary publication. Federal law doesn't require you to be in the PDR, but it's something that you can use to satisfy the duty under state law to give adequate warning. So branded companies traditionally put their medications in the PDR to be able to say, if it has a risk, I've warned of the risk. Generic companies are, in fact, relying on that PDR. That's what they're doing. They're saying if the doctor wants to know about it, look it up under the branded name, because the generic name is in the front of the PDR. So you can look it up that way, and you'll get the branded label. If they adopt for that purpose, as they do, that label, I don't think it would be a stretch for courts to say you've adopted it, you're responsible for it. If it's wrong, change it. And when the market shifts and the generics become the major seller, who else can keep up with the adverse events? And in the case of Reglan metoclopramide, the literature upon which the argument that the risk was understated was public literature. It was just as available to the generic companies as it was to the branded companies. And I think, you know, it's a fair and not a stretch to say, if you rely on somebody else's label to communicate information on your behalf, then you have to take responsibility for any failure of that communication.
And I would agree with that.
See, we agree on something.
Ms. Conti's claims and the claims of other plaintiffs who have both products liability claims against the generic manufacturers and fraud and misrepresentation claims against the name brand manufacturers don't want the generic companies to not be liable for their wrongs. They made the product. The name brand manufacturer has no control over that product, but the elements of that claim are different in California and in other states. And in some states it's a strict product liability, and in some states it's a negligent standard. However, the generic manufacturers, you know, like Conti, because it allows them to escape from their own wrongdoing and allows them to not internalize the costs of making a dangerous product. The generic manufacturers should be held accountable on a products liability warning, products liability theory, and their failure to actually provide warnings to the name brand manufacturers, because usually what generic manufacturers do, they just copy the name brand manufacturer's label, they put their own name on it, they put the own shape of their own pills on it, and it's the same warnings. It's no different. They have a duty to update that with the FDA, and they do have a duty to warn. The duty on the name brand manufacturers is different under a negligent misrepresentation theory.
Let me just add very quickly, the reason the generic manufacturer does that is because of the Waxman bill. The Waxman bill was essentially to encourage the quick release of generic drugs, so the generic drug manufacturer can get quick approval, just essentially copy the other monogram.
I just wanted to ask Mr. Schwartz, I agree with what Bert and Valerie just said. It seems to me that if the generic chooses not to do the research and adopts the opinion of the brand name manufacturer, have they not ratified their findings? And when the doctor reviews what's in the PDR, even though he may not know it, he has in fact relied upon what the generic manufacturer has said, because it's identical. So even though he may not know it, he has relied upon it because they ratified the findings.
I agree.
10 points.
Steve is right there. Yeah.
That's not the way the California Court of Appeals analyzed it, though. But I don't think we disagree.
3 very quick points on the Conti case, being from California and not being defensive about it. First, causation is almost always a jury question. This Court of Appeal managed to differentiate among the generics on the one hand and Wyeth on the other and send it back, and a jury may well find no causation. Second, the theories that seem to be viable against Wyeth are intentional fraud and negligent misrepresentation. And if Wyeth is nailed for intentional fraud, I don't have a problem seeing them bear the whole load. If they only are hit for negligent misrepresentation, then they have the ability to cross-claim for equitable indemnification or contribution among those generics, and then it'll be kind of fun to see how the preemption issue gets played out in drug company versus drug company.
And that's probably where litigation would head in California. At least that's what some have predicted, because Wyeth would sue the generic manufacturers probably.
One final question.
Just a general question on generics. How close of a duplication must a generic be to the actual brand name? And I ask that because I know of an instance where a pharmacist substituted a generic. It was in liquid form and had sucrose in it. The patient was very allergic to the sucrose. So when she took the generic, she had a reaction to it. But yet, the pharmacist was allowed to substitute that particular generic.
The generics have to be, there are basic types A, B, and BC. If it's AB, it's exactly the same. It's BC, it's not necessarily directly equivalent. For example, long-acting versus short-acting. In California, you wouldn't have been able to do the substitution, since you could only change the formulations if it's the same. And you must advise the patient, therefore.
There is, though, some variation in the inert ingredients, and I think that's what you're allowed to do. In other words, your active ingredient, there are 4 identities that you must have to seek what's called an abbreviated new drug application. You have to have the same dosage form, the same route of administration, the same quantity to be administered, and you have to have the same labeling. Those are set forth by federal law, but there is some flexibility in the inactive ingredients, and this might have been a variation in an inactive ingredient that created a different risk. That's really a question of substitution law. But it's important to note that while a generic must have the same label, varying only with the its picture and its identity, at the date of approval, it is entitled, once approved, it's the holder of a new drug application. It can amend that application just as a brand can. And the question is there any impetus in the common law for them to monitor what is happening with the product and amend and add to warnings when necessary? If Conti holds, if that's the law, they have no impetus at all. The best thing to do is do nothing, make sure your label is not distinct and that nobody ever sees it. If Conti doesn't hold, if there's a duty by ratification, then you have to be careful of what you're ratifying. And you have an independent incentive to find out what the drug might actually do.
Well, thank you to the panel.